are live in public session.
Right. Thank you. Let me just state at the outset, and then I'll turn it over. I was informed by Chair Nevis that because of a family medical emergency, he will be unable to attend the meeting today. He indicated to me that he has asked Commissioner Hinrichs to chair the meeting. So with that, I will turn it over to Commissioner Hinrichs.
Okay, thank you, Judge Berland. At this time, I'll call the meeting to order and start with the approval of the minutes from the two most recent public sessions, April 8th and April 26th. If there's any comments first.
Can you see me?
Mr. Vaughn?
Yeah. I wanted to make a comment. It relates to pages 4 and 5 of the minutes of April 8th, 2022. I had spoken about the independence of the commission and how important that is, and how I have not been in any way contacted by my appointing authority or anybody on the staff other than to be appointed. And I think I made a comment to the effect of, I don't know what was in the minds of anybody else who was on the commission. I just wanted to speak because I note from the minutes, and I recall that one commissioner, I don't know if she was upset particularly about what I've said, but I want to make it 100% clear. I've served on this commission now for about a year and a third. Obviously, I don't know what's in the mind and thinking of other commissions except when they've spoken to me. I don't know of any conversations that I may or may not have had with other people from their appointing authorities. But I wanted to make it clear as to me, and I also believe I said something to the effect that I see a big difference in the commission in light of some commissions having left and other commissions having been appointed since then by the newer governor. And I just want to make it 100% clear. I wasn't pointing my fingers at anybody in particular. And as to the commissioner said she was a little upset, that being Commissioner Gersman, I also want to make it 100% clear that having worked with Commissioner Gersman and observed her on through the commission and observed her on the commission, she's been a valuable member of this commission, has added a great deal to our process, and has certainly shown, to me at least, the independence of her thinking in casting her votes. So I wanted to clarify that for the record. I think it was important to do so.
Thank you, Commissioner Brown.
Absolutely.
Yes, thank you.
Mr. Chairman.
Yes.
First of all, if I may ask, we're addressing the minutes of the April 8th open session this juncture?
Yes, public session.
Yes. If I may draw your attention, Mr. Chairman, to page 6 and the paragraph that discusses the letter that was sent by Attorney for Governor Cuomo, Rita Glavin, to the Inspector General. I believe that the minute noted here does not accurately reflect what Attorney Glavin's letter stated. I believe that the letter essentially articulated the accusation that the enforcement action, which is Resolution 21-059, if I'm correct, was tainted by the fact that disclosures were made with regard to revocation and disgorgement that relied on information that was confidential within the ambit of the enforcement action. And this note in the minutes needs to be clarified as to what her accusation actually is.
Okay, thank you. Is there specific language you'd like to add to the minutes consistent with what you just said?
Well, I'm certainly I'm certainly willing to let Judge Berland and staff mill this through. But my basic premise, Mr. Chairman, and I appreciate your indulgence, is that the statement in the letter, the former governor's attorney asserted that resolutions that were deliberated and voted upon, revoking the Martin Levine approval, and subsequent resolutions deliberated upon and voted upon by the commission with respect to disgorgement were tainted. Well, that is a mischaracterization. That's not what I said. I know what her accusation is against me. Her accusation is that when I made statements to the Albany Times Union and the New York Post with respect to the revocation of disgorgement, I was relying on confidential information that was within the ambit of the Enforcement Act, which is resolution number 21-059. So this needs to be corrected commensurately, Your Honor.
All right. Subject to that correction, and Judge Berland, would you be able to amend the minutes to track more the language of the letter in question? Is that possible?
Yeah, well, I think we can go back to it was public session, so we can go back and compare the recording. I believe we've done that, but we will go back and compare that, and we will circulate an amended version of the minutes as appropriate.
Okay, thank you. So with respect to the minutes of the April 8th, based on that, is there a motion to table them at this time then?
So you want to table them? If you want...
Or approve them subject to the addition if everyone is comfortable with that.
Mr. Chair, this is Weissman. I'm happy to make the motion to approve the minutes subject to the new language being added to reflect Commissioner Levine's concern. To be done by Judge Berland and Commissioner Levine, I assume.
Point of order, Chair. We cannot amend minutes to add things because the meeting already took place. My statement before was a clarification of what I said, not to be added to the minutes for that meeting, but possibly to be added to the minutes for this meeting.
Table.
So although the minutes can be corrected, as Executive Director Berland said, by looking at the transcription or the recording, we can't add things to the minutes because the meeting of April 8, 2022 already took place.
Thank you, Commissioner Braun. Obviously, I was inartful in the use of the language I used. Thank you. Is there a second to Commissioner Weissman's motion?
Oh.
Commissioner DePere? All in favor, raise your hand. Appears to me to be unanimous.
No, it's not.
No, I'm sorry.
Are we votes against?
I'm sorry.
Yeah, I can't imagine voting to support minutes that are going to change in some unspecified way. That makes no sense to me, so I'm going to vote against it. I would rather see it tabled and come back and know what I'm voting on.
I apologize. I think there was 3 other votes against it as well then. Could I have the hands again?
Can we do roll calls for the votes
Yeah,
today, please?
Chair, could we have a roll call? We'll, if that's acceptable, I would ask Walt to just call the roll so we have a count.
Can you please restate the motion precisely? Thank you.
The motion was to accept the minutes with a subsequent change to be worked on by Judge Berland, reflecting Commissioner Levine's concerns relating to the paragraph on page 6, the bottom of page 6 of the April 8th minutes. Gee, I'm sorry I didn't table it.
May I ask a question? But wasn't there an agreement to go back to the recording to make sure? So you wouldn't be adding anything new. You would just make sure that what is in the minutes is accurately reflected in the recording of the meeting. Is that correct?
That was my understanding.
But Gary seems to want to have it reflect her letter. And if you didn't speak to what her letter said in that meeting, you can't put it in the minutes.
Gary Clumsy did. So we
Yeah,
gotta look
so-
at the recording.
But the transcription is important, not
Could
the
I
letter.
suggest that the
We
motion
table?
has to be tabled?
I'll withdraw my motion.
I'll withdraw my second. Can't we just,
I'm going to make a motion, this Commissioner Fisher, that we table this and we ask staff to revisit the transcription of the meeting to more accurately reflect what Commissioner Levine said and to distribute a new updated version of the minutes prior to our June 28th meeting.
Second.
All right, second by Commissioner Braun. All in favor of the new motion, please raise your hand. Opposed? Again, it appears to me to be unanimous unless I missed someone.
I believe so. I believe so.
Hold on a second. I have 10. Give me 1 second. Oh, I forgot Commissioner Levine. Yes, I have unanimous.
Okay, thank you.
All right, we'll do that. Staff will take care of it.
Okay, and a new set of minutes will be distributed after reviewing the tapes.
Yes.
Thank you. With respect to the approval of the minutes for April 26th, any comments? Is there a motion?
So moved, McNamara.
Thank you.
Second, Weissman.
Okay, second by Weissman. All in favor, please raise your hand. Opposed? Again, appears to be unanimous with respect to the April 26th, 2022 minutes.
All right, we just need to make sure we have all the votes.
I've got it, but from going forward, it would be easier if we could do a roll call because,
On each vote?
on each vote, just to make sure we get it.
Okay, very well. Yep.
All right, thank you.
Thank you, Walter. Okay, moving on to the report from staff, the operations update, Judge Berlin.
Yes, the operations report is behind tab C. As you will see, another big and busy month for the commission. There was a surge in anticipation of the May 16 FDS deadline. There was a surge in April in financial disclosure statement filings. Obviously, there will be an even larger surge in the May report. I did want to inform the commission that staff is busy working on the annual report. We expect to have a draft to circulate among commissioners toward the end of the second week in June, so that's moving along. This month, May 13th, staff published, the ethics group published an ethics reminder with respect to political campaigns. And on May 17, as required by the statute, the commission posted on its website the financial disclosure statements filed by statewide elected officials. So we've taken care of all of that. If there are any questions, staff will be happy to respond.
Judge Berlin,
Yes.
is this monthly operations report posted on our website?
It is not.
Yes, it is.
Oh, it is?
It's a link in the agenda for each meeting.
Oh,
No,
for
but
purposes,
this-
yes,
this-
it's not separately posted. It is posted as part of the documentation for the open session of the meetings.
So it is posted monthly so everyone can see what this commission has been doing in many respects.
Yes,
Thank you.
yes, and the statistics are, of course, incorporated into the annual report.
Thank you. Any other questions on the operations update? All right, thank you. Moving on to the attachment D, the emergency readoption of the regulations. Judge Berlin?
Yes, again, attachment D, we're seeking a motion to re-adopt, the second time, the emergency regulations amendments to the adjudicatory proceedings and appeal process, particularly the new disclosure regulations. They were originally adopted on an emergency basis and put up for public comment on a permanent basis in January. We re-adopted on an emergency basis in March in anticipation of expiration of that first emergency adoption at the April meeting. We extended the time for comment through the end of April. We have since received comments which are summarized under the tab, essentially asking for extensions of the period of time to comment pending adoption of legislation with respect to the current commission and the successor commission. Those are the only comments we've received. And what staff is proposing, we re-adopt on an emergency basis the regulations, extend the comment period to the end of this month, to the end of May. And then the commission can decide whether to leave the emergency regs in place through July 8th, or at the next meeting, proceed to a formal adoption of those proposed amendments. But at this time, to keep them in effect, we would request at least an extension on an emergency basis.
Okay, thank you. Any questions?
Mr. Chair.
Commissioner Gersman?
Yeah, I do have a question, and that is, in terms of trying to affect the most seamless transition possible from this commission to the new commission, which, as far as I understand, has yet to be appointed, which do you think would be a method that would put less on their plate in transition? A formal adoption next month so that they don't have to think about it, or an extension of the emergency through July 8th, in which case on July 8th they go out of business and the new commission has to think about what they might want to do. It would seem to me that there's going to be some transition and some acceptance of many of the functions and the procedures that we have put in place, and it might be easiest on the new commission if we in fact do a formal adoption next month.
Yeah, let me just respond to that briefly, and other commissioners may react to that. Under the new statute, ECRA 2022, the new commission will be subject to FOIL, the Freedom of Information Law. And they will be required by FOIL to adopt a comprehensive set of regulations implementing that. I suppose it's a judgment call whether these regulations would be superseded or obviated by the application of FOIL to the agency. And that's one of the reasons we thought it made sense to extend the comment period, at least for now, and let the commission decide at the next meeting what the best next step is.
Well, correct me if I'm wrong, that there will be some, even though it may be a FOIL request, they can still adopt, sort of for the time being, they can adopt processes and procedures that we have in place until they're formally replaced. Can't they do that?
That's a determination that I understand will be left to the new commission to judge. And I suppose they could assess it
It's
either way. I don't
possible.
want to predict how they're going
But
to.
it's possible that they can do that. That's my point, that FOIL would not require they're doing a total dump of all of our processes and procedure and starting from scratch, and that they could, if they wanted, have an interim set of rules based upon what processes and procedures we have in place. They might not, but they have that power. Don't you agree?
I am not. It's a legal determination. I think it's something. If we were going to have an extended discussion, I would suggest probably it should be addressed first in executive session. But my concern would be getting ahead of the new commission's assessment both of legislative intent and of the requirements of sections of the public officers law that constitute the Freedom of Information law.
I'm sorry, I just want to make clear that I would like the process to be as easy and seamless for the new commission as possible. And so that's my only interest in making the suggestion. But if this needs to be discussed in private session first, so be it.
Yeah, I mean, there is an item that on the agenda in executive session for the transition, and the question of FOIL and related regulatory issues is intended by me, at least, to be part of that discussion. So absolutely, we can talk about it then.
Thank you, Judge Yates.
Yeah. Once again, this points out how the draft that was rushed through during the budget process that, quote, reformed us, unquote, was actually poorly written and does not accomplish what it sought to do. And it's people will learn that over time when they have a chance to actually work it through. Our regulatory change was made to make us more transparent than even that which is required by FOIL. And that's what these regulations were intended to do. In the name of transparency, in a misguided fashion, the governor or the legislature put forward something that says they're subject to FOIL. So the net effect of not adopting these regulations would be to actually make the new commission subject to FOIL and maybe not as transparent as our regulations would have made them. So my own feeling is I would rather go forward in the name of transparency, and if the new commission wants to cut back on transparency, that's fine. But we shouldn't have less transparency just because of some poorly drafted bill that was rushed through during the budget session.
Thank you, Judge Braun.
Yes. Well, in the name of transparency, this can certainly be discussed in this open public session. As I've said before, I think in the name of transparency, we should be discussing as much as we want in the open session, except what's confidential and must remain confidential as a matter of law, and that's the purpose of the executive session. There's nothing confidential about this discussion, at least so far, so I think anybody who wants to discuss this now should feel free to do so. I'll make a motion now to readopt these emergency regulations as the amendments to Part 941 on an emergency basis.
I'll second that.
Would you accept a friendly amendment to also extend comment period until the end of May?
Absolutely.
Thank you.
Okay, thank you. With the motion and the second and the friendly amendment, any further comments before a vote? Okay, thank you. All in favor?
Can we do a roll call vote?
Yeah, Walter, you going to do it one by one?
Sure. Commissioner Braun?
Yes.
Commissioner Brown? Commissioner Brown?
Yes?
Okay. Commissioner DePiero?
Yes.
Commissioner Fisher?
Yes.
Commissioner Gerstmann?
Yes.
Commissioner Jacob?
Yes.
Commissioner Levine,
Yes.
Commissioner McNamara,
Yes.
Commissioner Weissman,
Yes.
Commissioner Yates,
Yes.
Judge Hendricks.
Yes.
Unanimous.
Hey, thank you.
All right, the next item is the proposed amendment to the recusal policy and procedure addendum to the commission members' code of conduct, which is under tab E. And I'm going to ask Keith St. John who would address that proposal.
So before you is a proposed draft of the existing recusal policy and procedure for members of the commission. It was asked of the staff to include or amend this recusal policy to include some provision for the exercise of actually doing something short of recusing from discussion and voting on a matter, namely abstaining from a vote, withholding a vote. And what is being proposed is a departure from the normal Robert's Rules of Order expectation that as members of the commission, the expectation is that you will vote on everything that's properly put before the commission. This slight amendment to the recusal policy would allow for members to, short of recusing, actually abstain from casting a vote on a matter that's properly put before the commission, but only on the condition that abstaining from a vote is being done because that commissioner feels that he or she doesn't have sufficient information upon which to make a decision or a determination. The reason for abstaining for a vote would be placed on the record and would effectively be final, so that once a member abstained, that would be it, and through the course of the roll call, for example, that abstention would be recorded and final, and not subject to change before the outcome of the vote.
Yes, Commissioner Weissman?
Yes, thank you, Mr. Chair. Whoever's going to make this motion, I would recommend a friendly amendment to the language that reads now to act in an official way and change it to undertake an official action, because I believe a vote is an official action of the commission. I wasn't quite sure what an official way meant. Does that?
It makes sense. Can you repeat it? What's the text?
To
base a vote to act?
Well, it would be to undertake, it would be to undertake an official action as opposed to act in an official way.
Noted.
Thank you, Judge Yates.
Keith, I have a question to Keith, and then I'm going to move to table. As I understand it, the new legislation actually specifically addresses the issue of recusal and alters the existing law in that regard and our existing practice. So I'm not sure why we would write something into our rules of practice here when the law is changing within about a month and a half, and there's going to be a new commission that may not want to be bound by this particular rule. I think the best thing would be to let the new commission look at the rule change and look at the statutory change, and for that reason, I move to table.
Second. Thank you. That was Commissioner Jacob with the second.
Okay.
Thank you.
Mr. Chairman.
Yes, Commissioner Levine.
Thank you, Mr. Chairman. Before we proceed to a vote, may I pose a few questions to counsel?
Yes, certainly.
First of all, has the commission ever had a protocol with respect to staff recusing in a matter, participation in a matter?
I'm not, who's the question being directed to? Me?
The question of recusal?
Either you, Keith, or Judge Berlin, does the commission have a policy with respect to staff recusing from participation in the matter?
We have had recusals, certainly of staff on several matters, yes.
But do we have a policy with respect to recusal by staff?
Yes, we do. In our policy manual, we do have a provision on a recusal where an individual has a potential interest in a matter. I don't have the language in front of me, but we do have a recusal policy.
Does the policy manual require the staff to give a reason for the recusal?
Not to my recollection.
Yeah, thank you. May I continue, Mr. Chairman?
Yes.
The current, this question will be addressed to Keith. The current policy provides that once a commissioner recuses, the commissioner shall receive no further information from the commission or commission staff regarding the matter, correct? So my question is, though, when the information goes into the public domain under the current protocol, is the commissioner still ostensibly, purportedly excluded from the information? Has that been the interpretation?
Yes, that is our practice. That's why we maintain a recusal list for commissioners, and we redact from the information that we distribute for each meeting. Now, from particular commissions are recused. Yeah.
Thank you. Mr. Chairman, one last question to council. The amendment proposed, if I understand it correctly, does not provide that a commissioner must state a reason for abstention if the reason for the abstention is other than lacking sufficient information on which to make an informed decision. Do I understand the amendment correctly?
I don't think you do.
All right, could you tell me where I misapprehend?
Under proposed section 6, the new procedure for abstaining from voting, if and when a member abstains from voting, the yeas and nays are recorded, as well as the abstention, and in the last clause, together with the reason for that abstention.
Thank you very much, Mr. Chairman, and the usual fine job by Keith. Thank you, Keith.
I'm confused because I thought the question was about recusal, not about abstention. Did I mishear?
Judge Levine, or Commissioner Levine's question? Is that what you're referring to? I understood him to be asking about abstention, not recusal.
Okay, my mistake. He was talking about recusal at first. I didn't catch the switch to abstention. Thank you.
Thank you, Judge Braun.
I thought the same as Commissioner Gershman, and there is an essential difference between abstention and recusal.
Absolutely.
If you vote, you're either voting yay, yes, nay, no, or abstaining. Recusal, you're recusing yourself from consideration and a vote, so you're not voting at all. So let's go back to Commissioner Levine. Didn't you speak of recusal and ask you a question about recusal, not about abstention? And the provision that Mr. St. John spoke to relates to abstention, which is different, as I said, from recusal.
Well, Mr. Chairman, the question specifically was about abstention, but I want to express my appreciation to both the judge and Commissioner Gershman for raising the other point. And I'll leave it to Keith to respond.
My response to Commissioner Levine's question regarding abstention was, as proposed, abstentions get recorded with the yeas and nays and the reason for the abstention. So my response is limited to the provision and the proposed new text, which only deals with abstentions and not recusals.
Well, again, at the risk, Mr. Chairman, of demonstrating my ignorance, I'll put the question to Keith. Under the current protocol, our current policy, commissioner recused, is the commissioner required to state the reason for the recusal?
I don't believe so.
No, commissioners are not required to state the reason for the recusal. As Judge Yates pointed out, under the new statute, there will be a provision for disclosure, I believe, to the chair of the reason, but we do not currently have that. We have added that requirement in the abstention policy because we understood that was what commissioners were asking us to provide, and to provide that the sole basis for recusal would be insufficient information in the commissioner's view to cast a vote on an issue properly before the commission.
In any event, at this point, there is a motion that has been seconded to table this issue, and I think Judge Yates was to table it till the new commission takes over. Was that the motion?
Yes.
Okay. Any further discussion before we take a vote on that motion that's been seconded?
I believe a motion to table is non-debatable.
Okay, thank you. Appreciate that, Commissioner Gersman. We'll call for a vote then on the motion to table.
All right, Walt, can we do a roll call?
Commissioner Braun,
Yes.
Commissioner Brown,
Yes.
Commissioner DePiero,
Yes.
Commissioner Fisher,
Yes.
Commissioner Gersman,
Yes.
Judge Hinrichs,
Yes.
Commissioner Jacob,
Yes.
Commissioner Levine,
Yes.
Commissioner McNamara,
Yes.
Commissioner Weissman,
Yes.
Commissioner Yates.
Yes.
11-0, motion passes.
Mr. Chair, can I just add one thing?
Yes, certainly.
I just wanted to say we should acknowledge that our staff did a very good job in working on this and putting together this proposed resolution that.
Thank you. So I can take the Band-Aid off my heart right now?
Unfortunately, in light of the change by the legislature and the status of this commission, the new commission coming in, this matter has been tabled, but the staff should be recognized for their work, and I do, and we all do, I'm sure.
Yeah, absolutely. Thank you for pointing that out.
Thank you.
At this point, any other new and other business while we're in the public session at this point?
Yes, Mr. Chairman.
Yes, Commissioner Levine.
Thank you, Mr. Chairman. On two occasions last September, the Commission adopted resolutions making a referral to Attorney General James to make inquiry into the breach of confidentiality that allegedly occurred emanating from the meeting of the Commission of January 2019. I now move that a resolution be adopted that the Executive Director communicate with Inspector General Lang that it is the request of the Commission that Inspector General Lang reopen the Inspector General's inquiry into the breach of confidentiality that allegedly occurred emanating from the January 2019 meeting. The rationale for the motion, Mr. Chairman, is that it would be highly contradictory and anomalous for the Commission, particularly as it is exiting, to not importune Inspector General Lang to reopen the inquiry that occurred in her own office. And I want to stress, Inspector General Lang, being new to the position, had nothing to do with the original inquiry, which was then under the aegis of the then Executive Deputy Inspector General. So consistent with the two prior resolutions that have been adopted by the Commission making the referral to the Attorney General, I now move that the Commission request of Inspector General Lang that the Office of Inspector General reopen its investigation of the same breach of confidentiality. Thank you, Mr. Chairman.
Okay, thank you. Is there a second?
Second.
Yes, second by Commissioner Jacob. Thank you. Any comment? Yes, Commissioner Fisher.
My comment is that this is a new motion. It sounds rather complicated. We did not receive it in advance. Yet again, there's been no opportunity to review it, discuss it with counsel, and therefore I'm going to abstain on the basis that I have insufficient information on which to base a vote.
Okay, thank you. Any further comment? All right. We'll
On
take a
behalf
vote.
of staff, Chair, if I may, just point out, this two things. This has been raised a couple of times and has failed before the Commission. And if there is a discussion, I would request that it be deferred to executive session, if there's no objection to that.
Yes, Judge Braun.
Yeah, that's the second point. As I've said many times, I believe very strongly in transparency of government, that includes us. But I agree with the Executive Director Burles. This, presumably, if this further discussion would include confidential matters, so though the Commission has the power to vote to allow confidential matters to be disclosed, there's been no such vote on this, and I think it should be taken up in executive session. Lastly, on the merits, without getting into anything confidential, I was appointed after the occurrences that are at issue here, so I would like to hear more. This is not entirely new, as Judge Berlin pointed out. This has been taken up by the Commission before. There has been discussion before, but I'm still not feeling that I have enough information, since a lot transpired in the past that before I came on the Commission.
Okay, thank you. All right, at this point, based on the comments, if there's no further comments, we'll continue the discussion in the executive session prior to a vote on the motion which has been seconded. Any other new and other business at this time in the public session? Thank you. Is there a motion to enter into executive session?
So moved.
Yes. Commissioner Brown, thank you. Second?
Second.
Okay, thank you. Second by Commissioner Gersman. I'll leave it to Walter for the roll call vote.
Commissioner Braun.
Yes.
Commissioner Brown.
Yes.
Commissioner DePiero.
Yes.
Commissioner Fisher.
Yes.
Commissioner Gersman.
Yes.
Judge Hendricks.
Yes.
Commissioner Jacob.
Yes.
Commissioner Levine.
Yes.
Commissioner McNamara.
Yes.
Commissioner Weissman.
Yes.
Commissioner Yates.
Yes.
Unanimous. Please stand by.
Who made the motion?
We are back in public session.
Okay, thank you. Judge Berlin, could you give us the readout from the executive session?
Yes, Mr. Chairman. In executive session, the commission discussed matters related to litigation or legal advice and approved certain action in one matter. The commission acted on 2 requests for informal guidance pursuant to Executive Law, Section 9416. The commission approved 2 settlement agreements in investigative and enforcement matters. And the commission authorized steps in several investigative matters, closed 1 matter, and discussed several other investigative matters and referred 1 matter to committee.
Okay,
And
thank you. Is there a motion to adjourn?
So moved.
Second,
Commissioner
Fisher.
White, thank you.
Fisher,
Thank you,
second.
Commissioner Fisher.
We can do a show of hands for this last one.
All in favor, raise your hands, please.
Aye.
All right,
I have unanimous.
it's unanimous. Meeting is adjourned. Thank you very much.
thank you, everybody. Everybody be well.
Thank you.